Welcome to our favorite subject, which is medicals and IMEs. So what are we going to talk about today? First, how medical treatment obviously impacts exposure. So this is something we want to focus on. And I'm going to try to point out the grenades. Where can we have fun with this? Where can we push this? What should we be looking out for? Okay, so that's our goal. Our goal is to be as proactive as possible, not reactive. Just because they're getting medical treatment doesn't mean we're in the backseat and they're doing all the driving. There's still some things that we can do. Paraprofessionals, please don't tune out. This is your wheelhouse. This is an opportunity for us to go and find those little golden nuggets that we can then deploy and turn into a tactical advantage in our case. So I know that sometimes it's frustrating. We're running the list. There's a lot of medicals. We're scanning through it. I heard today some people say, well, I go right to the end and see what's changed. That's useful. I would also say sometimes you'll find something juicy in the medicals if you actually scan through it, particularly the subjective complaints area where they say, oh, I'm a little sore today because I played a round of golf or something like that. And they just give away something. And they say, I've missed a whole bunch of appointments. Why? Oh, because I was on vacation with my family for a month or something like that. Like those are little nuggets that if you find them in your case, let's amplify those. Those might be a signal to us that we could do something in our matters. Another interesting thing that I would say we should look out for, you see C-8.1Bs. So our client is objecting to a medical. The board just issued a memo last month that said that over 1 million medical disputes were filed last year. 1 million. Does that number sound insane to anyone? Which they said was a 20% increase over 2022. So that's tremendous. So there's more medical fights going on. So we know this topic, when we talk about medical in our cases, it falls into the part of the cases where we have to generate leverage. That means litigation, and we've got to come up with something. And everyone knows our litigation model here. Do some tactical actions, see what happens, tell the client about it. Remember, if you don't tell the client, it's like it didn't happen. And then you revisit your plan, right? That's the loop that we try to get our cases into. That's where we should spend most of our time, theoretically. And I promise, if you go through this loop a few times in your cases, you find something, you raise a tactical point, you make the other side work for it, you make them get off their butt a little bit, you make them respond, you make them go to a doctor, you do something, I promise, 3-4 times through that loop, your case will close. We have to do the effort to do that, though, sometimes, and that's our challenge. How do you apply that to what we're talking about, medicals? Well, the tactical action here is going to be challenge unnecessary treatment. It's going to be to obtain contradictory medicals, usually by way of IME. But what's the other way we could do that? A records review, right? We're going to come up with something to contradict the direction the case is already going in, and then hopefully push it to take testimony, their doctor's testimony, the claimant's testimony, something. We're going to try to get someone on the record. Again, that's where we spend our time. That's how we get case closures to occur. Now, basics. I'm going to skip through the basics. I deleted most of the basic slides in here. Claimant's always entitled to medical, both curative and palliative. Curative medical is that which is actually making you feel better and get better, meaning you are actually restoring function. The person's activities of daily living are improving. So there's something that's happening and you can see there's medical progress, okay? Do we see that in our cases? No, because chiefly they're about palliative care. They're just kind of keeping the person at baseline. They never seem to be getting any better, and they never seem to be reaching maximum medical improvement. And years and years and years and years go by, and it never seems to be getting any better. So what do we do about that? That's what this whole presentation is about. Now, we know the claimant in any workers' comp case, they're entitled to unlimited medical benefits. They can choose their own doctors. Do they choose good doctors? No. What doctors do they go to? The ones their attorneys send them to. The medical treatment drives wage replacement, okay, and that's really the game here. This is all about money, both for the claimant and for the doctors that are treating them. The course of a typical case, or the way it's supposed to work, is they get curative and palliative care. Eventually, they reach maximum medical improvement, and then we're ready to move on to permanency, or they're restored and they can go back to work, right? Like those are the basic steps of a case. But our cases don't work that way. You don't see the normal cases. We don't see the 85% of people who get injured at work, get some medical treatment, and go back to work, right? Like my mom had a workers' comp case, and that's what happened in her case. We only see the 10 or 15% of cases where this gets broken, and they never seem to reach maximum medical improvement. So we have to deploy our little tactics or strategies to try to move the case to closure. And I'll tell you, when you attack medical treatment and you stop the wage replacement benefits, that's the tactical lever that you can push in your case to get the other side to start at least talking or paying attention to you, because they have to, because guess what? You just drove it to a hearing, right? Like, that's your goal. That's a win. I know we do celebrate wins here that are like, oh, we closed the case and we found fraud, but like, I think just finding a tactic that you can deploy, like, that's a win. Like, that's actually the emotional labor that we actually do, right? Like, that's the value we actually add. And it will have a strategic impact on your case too, because, you know, if you can reduce the amount of unnecessary medical care, or you can keep out the treatment for unnecessary body parts, well, you're going to lower exposure or the overall award value in that case. And that's a win too. So, you know, I know this stuff doesn't always feel like a win when we're pouring through medical records and we're looking for those vulnerabilities, but that's a big part of what we can do. Body parts are established right at the beginning of the case. As soon as the claimant says, oh, I hurt this body part, and they produce any medical records from any doctor, that is prima facie medical evidence, and that's enough to establish the body part into our case. Okay? It's flimsy. It's one of the presumptions that's afforded to them in the workers' compensation law, but that presumption can be rebutted. I think Olivia was talking to me about a case today where we looked at where the doctor's description of how the accident occurred or the mechanism of injury, and that changes. And if it's wrong, well, then everything that follows is wrong. So that's a rebuttable presumption as long as you can find some problem. We talked today a little bit about, hey, where the doctor seems to be copying and pasting notes over and over again. They don't even seem to pertain to this individual patient. They could be from some random patient, and you see the same notes in every single case. Dr. Sebastian Latuga. All right, so I think medical records are a gold mine. Okay, if you are running the list, this is an opportunity for us to find this stuff. Let's look for it. Look through the records carefully. Look for some tells, right? Is it an in-person visit? Is it clear from the record it's an in-person or not in-person? Is it telehealth versus not telehealth? Now, doctors don't even have to be in the same building as the claimant to the medical records that they're signing, right? The telemedicine rules allow them to practice medicine remotely, essentially have their nurse practitioner sign the medical records saying that, hey, I observed them, but they're putting the doctor's name up and they weren't even there. How are you going to find that stuff out? Well, you're going to find that out during testimony, right? We're going to have to put them on the stand. So look for those things. What is the doctor, what kind of history did they take? Was it correct? And is the claimant's story changing? Is that mechanism of injury? Is it first I fell down a flight of stairs and then it was a car accident? And how is it every case 2 years into the case, all of a sudden, oh, I remember now, I bumped my head, right? And they start bringing in a closed head syndrome or TBI case. An easy thing to do would be to look for the CA1Bs. The board just released more guidance to carriers and employers in when they can and should not file a C-8.1B. That was released in January. So if your client is disputing the medical, that's probably a good hint. Hey, there's a problem here. I should be looking into this. This might be an opportunity for us to create leverage. All right. What about those cases where it's an established site and the medical is to that established site? I think that they're treating a lot of time just because it's an easy way to get money. You go to the doctor once every 90 days. That's what the law requires. That's enough to keep the wage replacement spigot flowing. And that's what's pushing or driving these cases. All right, a second maybe red flag would be they have a third-party case. So they have a rinky-dink injury on a construction site. It's not impressive. It's a sprained ankle, but a sprained ankle in the civil world is worth a couple $1 million probably. So they're going to try to treat as much as they possibly can. Why? Because when they get in front of the jury, they get to put it up on the board and say, here's all my medicals. Look at all of this treatment. Look at all of this cost. Look at all this time. So they have a built-in secondary gain motive or incentive to overtreat, and the doctors are not cutting them off. And of course, the last thing is the doctors who don't find MMI. So how do we challenge this stuff? Well, do we have some fact that contradicts it? And oftentimes we won't, because it's just the claimant going to their handpicked physician who's going to spit out the same parroted report over and over again, full of subjective complaints. That's what we see all the time. Is there something that we can come up with that's non-medical so that we can challenge the treatment. And here's where I'm thinking, and we could maybe make better use or make use of those surveillance videos, which aren't so good, like those surveillance videos that don't show the person working or jumping on a treadmill or playing badminton or pickleball or something. They're not, amazing videos, but it certainly shows them going about their activities of daily living in a way that they've concealed or withheld from their physician. That's enough, I think, for us to file an RFA. Maybe not for fraud, but to say, hey, this doctor, they've concealed their condition from them, and that's enough to try to get that provider onto the stand and try to create some of that jeopardy. Again, I know this is a short-term thing. Even when the medical goes stale, sometimes the board is going to be so slow in listening this for a hearing that by the time it happens, they go back to the doctor. But this is at least a tactic that we can deploy. It's one of the few that we can be proactive about to try to gain some leverage in our cases. Now, I think we have to look at the treatment when we think it's getting into that unnecessary category, and we have to attack it quite vigorously. I'm sorry, if you went to the doctor because you had a sore throat and you started treating with the doctor and they went through a couple different courses of care, and 6 or 8 months later, your friend said to you, how you doing? Oh, I still have the sore throat. Wouldn't your normal human being say to you, like, okay, go switch your doctors, like go to a different doctor? How come in workers' comp world, like you go to the doctor because you sprained your ankle and a year later you're no better and you're still going to the same doctor? Like that's just not normal, right? Like I know we're practicing in this world, we get like jaded to it and it almost seems like, oh, that seems normal. Like why would you ever switch physicians? Any actually in pain, injured person would be going doctor shopping as fast as they possibly could to try to find a cure for their actual condition if it actually existed. But it doesn't, and that's why they don't pursue it. So, we've got to challenge that, and we've got to try to get on top of it. Of course, I blame the doctors a lot because they're playing this game. I mean, they're just scamming the system. That's all these doctors are doing. But also we have to look at what the claimants are doing because they have control over this. How can they draw this out, right? How can they extend their stay? Well, do things like selecting bad doctors. Hey, the doctor says after they see you, you need an MRI. Well, waiting 2 months to go get your MRI. You just got 2 more months of wage replacement during that period of time. Maybe you beefed up your claim for a protracted healing period, right? Maybe you're improving your claim in the civil arena by delaying getting that treatment or testing. They only have to show evidence of disability every 90 days. And when you see them slow down the pace of seeking care, or the care turns purely palliative, right? Like I'm going to physical therapy for 2 years. Guess what? After the first 6 months, it's not really doing anything. Maybe it makes them feel better. Maybe it's keeping them at a plateau, but it's not actually improving them. So we have to attack that. So when you're attacking that, you're not just gaining that little bit of leverage you need to get to a hearing and make the other side pay attention to you. You may also be reducing the overall strategic exposure in the case. So this is why this is valuable and fun to do. I know, like Joe teaches the course on fraud. Like fraud's way more fun than this, but this is like the meat and potatoes of how we get traction in the case where we've lost control of. And when you start eliminating the body parts and slowing down the rate of award, like you're ultimately going to reduce the overall exposure to the client. And again, this is the work we have to do. When you do that, your job, and you have contradictory medical, or you have arguments or facts that you can present, now the judge has the job to do. The judge has to weigh the contradictory medical. Now, the case law says the judge can wholly reject the treating physician. They can adopt some of their findings, or they can do a mishmash. They can sort of find somewhere in the middle. That's fine, right? That's movement. That's leverage. That's momentum, right? Making the judge do their job. That's fine. What I really want us to stay away from, and there is a prohibition here on tentative rates. So you've got an IME that shows the person is ready for the Olympics, 0% disability, go back to work. Their doctor says this person is completely disabled. It's a miracle they could even make it into my office today. What a stoic hero, right? That's what their physician's saying. And you go to the hearing, the judge says, oh, can't we just compromise this and do a 50% tentative rate? Please never compromise on a tentative rate. That's my position. That should be our position. I think that's the best practice. If you're offered a tentative rate, you're now in the driver's seat. Please reject it. Please reject it. it's going to put you in a better position for settlement, and it's going to open up another opportunity for you, which is, hey, you might find them, the judge might find them less than total, and now we can raise labor market attachment, which is a way stronger defense and a way better mechanism for creating leverage in our case. So please never concede to a tentative rate. And I'll just give you the 1% exception. When you already have a Section 32 on the table and you're ready to close your case and you're just get along, go along, okay, I'll agree to a tentative rate because we have a Section 32, it's signed, and we're just waiting for that to occur. Okay, that's the one exception that should probably occur like twice in your career. Okay, that shouldn't happen. So tentative rates really shouldn't occur. Second thing that we're trying to get past is opposing counsel saying, oh, we're not ready to talk settlement with you. Claim it's not an MMI. Well, here's a secret, counsel. They're never going to be an MMI. Ever in a million years are we going to wait for their doctor to MMI them. Why would they? This person's like the best annuity that you could ever purchase. They just keep coming into your doctor's office every 2 weeks. You write the same report, probably takes 3 seconds, and you get paid $200. I mean, it's like if I was a physician, I mean, this is a scam, and this is what's going on. So you can't wait for that because the doctor's never going to MMI them ever. And we know maximum medical improvement, actually to have a treating physician find it, well, if you find one of those, that's like gold. I mean, I'd be surprised. It'll happen probably 2% of your cases. It never happened in any of mine. What is it? What's the definition? Curative treatment has come to an end. They're not getting better. The doctors will still come up with more tests, more treatment, more physical therapy, more meds. Even if the person's not actually recovering, they'll never say it. So as soon as you see the case is stalling out, let's say there's been a year of this nonsense and you've seen no improvement, let's just raise MMI by way of RFA. That's fine. You don't even need medical. You don't need contradictory medical. You can say, Judge, look at this. Wake up. Smell what's going on, what we're cooking in the kitchen over here, Your Honor. This is just not moving forward. Make an attempt. Now, sometimes it's the doctor, right, that's resistant to MMI. But a lot of times I think it's the claimant. And I think it's a valid basis for an RFA, just to say, Judge, it's been a year. There's been absolutely no improvement. Can't we just call this? Shouldn't you order the parties to move on and get their C-4.3s? Isn't it time for permanency? If you look in your medical records too, you might not see the term maximum medical improvement. It might just not appear in, right? But as soon as you see a word like fixed and stable or come back whenever you want, right? Come back whenever you want is you're done. I can't, even though you might come back, you're done. That is MMI, okay? File the RFA too. You should get a hearing and we should be able to litigate the case and move it on to either permanency or parties getting reports. And I think that's what we need to do effectively. Again, this takes effort, and we have to look at the medicals as they come in on our cases. So please, you see them come across your desk. I know it's tempting to just kind of go, oh, it's another one of these, but take a look at them. Sometimes cases that, I'll admit this, I'm prepping a case for trial, and I say, okay, I'm going to go back and look through all the physical therapy notes. And I find things in those physical therapy notes that they told the physical therapist that they recorded that was super useful, right? Where they've admitted, oh, something else happened. I got a new accident, new injury, superseding loss. I've been doing this other activity that I haven't revealed to the treating physician. All right. The next thing I want to talk about is undue influence. I don't think we raised this enough, and I think this is a great ground for us to explore the intersection between the claimant's attorney's advocacy and a violation of our ethical requirements. So undue influence is relatively underutilized, I think, and I'm going to talk about something that it's developing now that we should be thinking about. So first, we all know the handicap that we have in litigating these cases. Our side can't communicate with the treating physicians, right? Only thing we're supposed to be doing is just getting bills and paying them. But we're not allowed to communicate with the treating physician and say, hey, do you really still think they need more of this care? Hey, doc, it's been a year. You're not getting any results. There's no progress. What are you doing? We're not allowed to ask that question, right? The only way we could ask that question is in writing, copy to all parties. And is the physician going to respond? No, they're not going to respond at all. Even when, years ago, when I would get fraud videos, I would send them to the treating physician, like if they weren't like tremendous frauds I needed for surprise, and I'd say, hey, I've got a video of this dude doing all this stuff, and I would send it to the treating physician before their deposition and say, hey, is this going to change your opinion? They wouldn't even bother to read or watch those videos before I depose them. Like, they don't really want to do any work. They don't want to respond to us. So I know this is kind of a waste, and it doesn't really go on in our case, and certainly not from our side. But I certainly think the other side has a lot more interaction with the physicians than we do. First, they're selecting them, right? Second, they're cultivating them as referral sources. So I know there's a lot more overlap there and a lot of informal communication that I don't think that we're really a party to. And so these undue influence rules, they apply to us and they apply to opposing counsel. And as I'll talk about in a second, I think they also apply to other parties, third parties that maybe we're not always thinking of. So contact with physicians, interfering with somebody's experts, disallowed, that's an undue influence. Communicating with opposing counsel's doctors without copying an opposing counsel, we're going to get slapped with a penalty. We all know those things. We don't do that here. The penalty, by the way, where you discover an undue influence, is that doctors' records might be completely precluded. So their evidentiary value or their use as parole evidence will be foreclosed. So that's an awesome weapon for us to deploy. Again, I don't think we do it enough. Where the opposing counsel has done this, they might be foreclosed from from cross-examining that witness if they've tried to influence them. Now, I have a personal case that this happened in, and I want to talk about that case just for a second and remind everybody about it because it was quite pernicious, and opposing counsel engaged in an undue influence, but didn't believe he did, and actually on the record talked all about how he did communicate with the physician, but said, I'm allowed to. So in my case, it's a matter of Paksinski. The claimant's attorney in the workers' compensation case also represented the claimant in a civil action. Imagine this, guys. It was a construction site accident. Peter Paksinski claimed that he was injured in an elevation injury. His elevation injury was he stepped in a pothole on a construction site. Okay. Now, his attorney sent him to a series of physicians who diagnosed everything in the world, including TBI and all sorts of crazy stuff. And during the pendency of his case, it was clear that he was just using the workers' compensation case as a piggy bank to bank up as much medical care as he possibly could so he could go prevail in his civil action and try to recover millions and millions of dollars. Because his attorney represented him in the civil action, he was communicating directly with the physician and actually directing the physician on how to prepare for his deposition with me. So when I take the claimant's the deposition of the physician, one of those basic questions that you ask, right? We all ask these questions. What did you prepare for today's deposition? Did you communicate with anybody? Did you communicate with the other side? This physician actually said, yeah, I did. But just claimant's counsel, who's on the call today, communicated with me and we went over the questions you were going to ask me for my deposition. And I was like, what? This is amazing. I'm going to move to preclude. I've never had a physician absolutely admit it. And claimant's counsel said, well, I was communicating with you because I'm also representing the claimant in a civil action. And under the civil procedure rules, they are allowed to communicate with the treating physicians in a civil action. That's allowed. The workers' compensation action is foreclosed, in a civil action it is. So this attorney's position was, yeah, I admit I talked to this doctor. I admit I've helped him prepare for his testimony. The attorney, by the way, was Plata Law Firm, so we still have lots of cases with them, right? So this is not like something that happened a million years ago. He admitted, I said, that happened. I said, well, I'm moving to preclude. Went before the workers' comp judge. On the record, I said, Judge, you should preclude all of this treating physician's opinions. It was Dr. Jason Brown, who we don't really see around that much anymore, but he was one of the, I don't know if he's a neurologist or a psychologist who was treating everybody for closed head injuries and TBIs. Okay, that was like the flavor du jour. And by the way, his treatment method was to put them in a room and let them play video games because that somehow would cure their condition. Again, made up conditions. Went before the judge and I said, Your Honor, every record should be precluded. The doctor should be thrown out. Claimant's counsel admits he tampered with this witness. And I also think he should be penalized for the undue influence, and you should throw out all the records. Again, in that hearing, opposing counsel said, yes, I admit I did that, but I'm allowed to because I represent him in the civil action. And under those rules, I'm allowed to communicate with the treating physician. Well, the judge of compensation agreed with us. It went up to the board panel. The board panel agreed as well and said, no, that's ridiculous. We threw out all those records, and that case settled for a very, very small amount of money. It also had a very big impact on the civil action in that case. Go ahead. I see your hand raised, sir. He was penalized by all the records being thrown out, which established essentially all of the claims besides the stepping into the pothole case. Okay. So yeah, it had a big impact on the case. So, you know, I think this is a frontier or something we can be doing in our depositions to explore a little further. Also, last year, we talked about in November the amount of fraud that's in our system. And I think the tradesman case and its progeny, there's now 3 follow-on lawsuits, are demonstrating to us like, man, there is a lot of collusion going on between these certain group of doctors, Surgicorp, Marola, Latuga, etc., and this certain group of attorneys. There seems to be a heck of a lot of collusion going on here. And those lawsuits are pending. We're going to see how they go. But what also came out last year, and we talked about in November, was the fraud between the litigation funding companies, because we don't always think, you know, there's a civil action going on, but somebody's paying for that civil action or somebody's pushing that civil action. And there was a case last year in which the doctor's testimony was found to be tainted, not because the doctor talked to the claimant's attorney, but because the litigation funding company's representatives were directly communicating and directing the doctor. So I would like us in our depositions of all claimants' doctors going forward, treating physicians, don't just say, hey, did you communicate with claimant's workers' comp counsel about this matter? I think we should be saying, did you communicate with any party? Did you communicate with anybody even regarding the civil action? Did you communicate with anybody at the litigation funding company? Because if you look at those tradesman cases and you look at some of the other cases that have been filed in the last year, you'll see the litigation funding companies are the silent party in the background that's directing and in some cases allegedly paying for some of this unnecessary treatment and incentivizing claimants. So this is definitely something to explore when we're doing our cross-examinations. There should be at least 1, 2, or 3 questions in your sort of standard format cross-examination of the treating physician. Hi, did you communicate with claimant's counsel before this deposition today? Did you communicate with them at all during any of your treatment course? Have you prepared with them in any regards for any other case that may be pending? And have you communicated with any other party, and say, including any litigation funding? So where you have a civil action, I think you should be absolutely, or the potential even for civil action, you should be asking all those questions during your voir dire. Okay. Now we know what's happened when we ask questions about the physicians who have been accused of collusive behavior in their depositions. They get a little spicy sometimes, right? And they get uncomfortable. And I know opposing counsel doesn't like it, that we're starting to cast a light on what's going on there, but that's okay. That's our job, right? We're professionals that are here to protect the system from stuff like this. This is part of our role. So undue influence, I think this is something for us to push a little further. I also think the board might become more receptive to this line of questioning, just in light of the fact that all of these fraudulent lawsuits are coming out. In light of the tradesman case, this probably is not going to draw the ire of the board if we start exploring it. And again, our job is to protect the system. All right, let me finish up today by talking just a little bit about independent medical examinations. These are the 2 double-edged swords. Sometimes they help us, sometimes they kill us. How are we going to get better independent medical evaluations, and how are we going to get better opinions and better doctors on our panels? What are we going to do? Now, first, yeah, they are not really independent or impartial because we're selecting them, right? And really, we can't tell them what to say before they testify, but we can sure help shape it, can't we? And we can also, moving forward, work together collaboratively with not just this firm, but like the whole bar, that when these IME doctors start turning in opinions that are off the mark, not based on objective reality anymore. Stop using them, right? We have to move on. So we have to use that power of selection to make sure that we're not stuck with these bad opinions. Okay, this is how we can protect our clients. Now, we can't direct them what to say. Remember, that's an undue influence. But we could choose to do some things to maybe prepare ourselves better. I think we should be recommending records reviews to clients more often. I think that helps us prepare a little bit better. I think that we should be vetting the IME doctors instead of just letting our clients pick them. They're not always picking the best ones. They might just pick the one that's cheapest or the one that has the next available date. Those are not really good reasons to pick a medical expert because they're cheapest or they're the most available. There might be a reason they're the cheapest and the most available, right? That's not really how you pick the best restaurant to eat in. Why would you bet your case, which could be hundreds and hundreds of thousands of dollars on, well, this is the one we found who is within 6 miles of the claimant. Like, that's really not enough. Okay, so let's help them vet. I want specialists. I want good credentials. In general, they all have great credentials. We only are using board certified physicians for this role. But I really think the thing that we should focus on is prior experience about how they tested them. Prior experience. Now here at LOIS, the way we should be talking about this is probably in LOIS Lincoln in our chats, like, took this doctor, guys, let's stop using them. They departed from their opinion, right? What's the worst thing an IME doctor can possibly do when you have them on the stand? My opinion is start responding to speculative questions posed as hypotheticals by claimants, or start speculating about the claimant's future medical course, or just in general departing from the four corners of their opinion, right? That's when you've lost control of them. That's when the claimant's going to take them on an adventure. You know, when they start asking questions that sound like, doctor, you may not know this, but after the claimant saw you, I saw them in my office a week later and they were in such pain and they could barely move their arm. Now, doctor, if you knew that, would that change your opinion? Those kinds of, you know, just broadly speculative questions, or saying things like, isn't it possible this could worsen, that kind of stuff. Those are that's hypothetical, right? We should be prepared with our objections to shut that down as fast as we can. I think internally, we should be searching through our document management system to make sure we're using doctors that we've had good results from in the past. If we don't have one, this is something, by the way, for office hours. Okay, office hours with your partners. You say, hey, I got this bad case. It's going to be a couple $100,000. It's looking like a 50% or more LOEC. Let's talk about who the right doctor is. Like, that's a great opportunity to lean on someone with more experience. We get an IME when we need to create contradictory medical, right? Like, that's the point. And if you come back with an IME that just agrees with the treating physician or just parrots the subjective complaints, that we didn't do our job. I think one of the things that we should be thinking more about is the cover letters. I'll be pushing on the clients who don't allow us to write the cover letter to say, guys, you're wasting a huge opportunity here. You're just putting this in the hands of whoever is cheapest and available in the state, and you're giving away some of your power. Making sure they're not just parroting whatever the claimant's complaints are, or just giving you the same report over and over again. Now, we still have Section 137 problems with our reports. The doctor doesn't turn it in on time. Opposing counsel moves to preclude it. Okay, sometimes that happens. I would also like us to be more aggressive with trying to preclude our own reports that don't help us. Look for a Section 137 violation yourself. Get your own report thrown out. Say, Judge, we can't possibly rely on this report. It doesn't comply with the black letter law of Section 137. Look for the violation. Look where maybe the same record that was submitted to E-Case was submitted twice. Try to disqualify your own expert where that report is not good. Again, I think that's a Hail Mary situation. Let's try not to get into that. Let's avoid that. My advice is the cover letter is the key to this. We can't coach the doctor. We shouldn't be too persuasive, but that doesn't mean we can't pose the questions to them in a way that's going to get us the answers or the response that we could actually use. I was sitting there, and today we were shooting that B-roll, and someone said, hey, look, the cover letter, make sure the doctor actually addresses your issue in the case. I think it was Moshe who said, if you don't want them to comment on causal relation, but you do want to comment on the degree of disability, because maybe the causal relationship issue's up on appeal. Tell them that in your cover letter so you don't deep six your own tactical defense or what you've already done in the case, right? So I think we could be very pointed with our IME cover letters and use them as directionally as humanly possible. And do a really good job to make sure that, hey, we don't, it's unpredictable, I get it. It's a black box. We don't know what result we're going to entirely get when we put all these ingredients in this pot and start cooking it. But man, we can set ourselves up to get a better result. And by the way, I hate relying on IMEs. Like if that's the only thing we have going on in the case, I mean, it's a flip of the coin sometimes, right? I get that. I would also tell you that if your action plan in the case is, basically I'm just going to let this thing just kind of like float down the river and then eventually I'll get an IME. It's not a great action plan because that's an unpredictable result that you can get from that tactic. So just sometimes it's the only tactic you have, and I get it, but I would be scratching my head. And again, maybe that's a case to bring to office hours and say, hey, can we think of anything else that I could do in this case other than an IME? And the last thing that I'll touch on is, all right, what if we don't get an IME? What if we do record review instead, right? Like look at your case and say, is the physical examination entirely necessary? Or another thing you can do is get a records review in a bad case, get an idea of how the answers are going to shape up or what the opinion is going to be, particularly in a case where it's like, do they need another surgery, right? Where there's going to be an automatic par or a variance request because it's going to be a repeat surgery. And you're like, I don't know. And you don't want to hand it over to an IME doctor. A records review would be a good idea in those kind of scenarios. Why? Because the record review comes back and you don't like what the record review says. Guess what you do with the records review? Well, someone said garbage, but no, we would just keep it in practice, master. We would delete it, but we don't have to file it, right? We don't have to rely on it. Now, if we do intend on relying it, then we do have to turn it over to opposing counsel before we rely on it in court, right? So we can't surprise them in the proceeding with the record. It actually says that in the rules. But if you get a good records review and you like it, you're like, okay, I'm going to rely on this one. Okay, that might be one that you're going to strategically turn over to opposing counsel and use that to defend either the variance denial of the par or whatever brought you to that sort of moment. I had one case, this is a long time ago. Here's how long ago this was. Alicia White was my paraprofessional at the time. And it was a cancer case in which it was a really strange, the allegations of causality were, I think, quite tenuous. And I got an expert and opposing counsel got an expert. And I knew the judge, this was in Hauppauge, this is back in the days when we went to court. And I knew this judge was going to say, okay, we're going to have to send this person to an impartial. And the board maintains a list of impartials. So my strategy in that case was what I was going to do is get a records review done by every single impartial on the entire list, and thereby conflict every single potential impartial on the board's list for respiratory disease out, so that the judge would have to rely on either our expert or theirs, because I liked my expert, and I thought it was Dr. Conowitz. I knew he was going to testify really well compared to their expert, right? So again, we can get quite creative with how we deploy these record reviews and what you could be using it to do. I'm quite certain when the rule was designed, they weren't thinking somebody's going to go and retain every single impartial to conflict them out of their cases. But this is how we can, by studying the rules, apply them in such a way to put our clients in a beneficial position. And the last concept I'm going to talk about today is one that I talked about last month, but I haven't seen an uptick in recommendations of this concept, and therefore I'm going to keep talking about it until I see an uptick in recommendations for this concept. And this concept is the functional capacity evaluation. Okay? I love functional capacity evaluations. Why? They are about as objective a test of the claimant's actual functional impairment as you can possibly get in this world. I like functional capacity evaluations that are conducted either by a physiatrist or someone with a doctorate in biomechanical engineering. Okay, those are the two I like. I don't like functional capacity evaluations that are done by physical therapists, and certainly not ones that are done by chiropractors, because that's not science. Okay, what I like is a good functional capacity evaluation conducted by a reputable scientific company. I recommend kinematics for this, but there are others that will subject the claimant to a physical test that attempts to simulate a typical workday, either in their industry or some other industry, all right? And what this test really looks like is like a person basically goes to the gym and they're there with either a biomechanical engineer or a physiatrist, and sometimes both, depending on which vendor you select, and they put them through like physical tests, like almost like what a personal trainer would do. They set up machines to simulate doing work at different capacities, turning wheels if they're a driver, stepping into things, stepping down from things, going up and down ladders, and they test them. And these tests don't take an hour or 10 minutes like these IMEs do. These tests take 4 to 6 hours. They are videotaped. They will often have digital sensors embedded in the testing equipment, so they get a really good sense of the claimant's effort that they're putting into the test. They can tell if the claimant is not trying. Go ahead.
I've asked IME before, but FCE would be useful, but how do you suggest we get these done in the form?
Okay, so that's the best way. The best way is actually to have, so if you can't hear this at home, Declan said, how do we get these, Greg? How do we get these done, right? So there's two methods, I would say. Number one is in our cover letter, and these should be in our high exposure cases, because a good functional capacity evaluation is going to cost between $8,000 and $12,000 for a one-day test. It's going to be costly, and it's going to be costly not just because the test takes 4, 5, 6, sometimes 8 hours, but also because a good one will be videotaped, and then afterwards you're going to get a good report, like it's usually a couple of pages long, written by the physiatrist or the biomechanical engineer, that explains exactly what the person's physical capacities are, and also if it was a valid test. In other words, they will talk about measuring effort. So it's costly. You're not doing this in every case. But in your high exposure case, your case where it's something like, hey, it could be a 75% LWEC or above, or very significant exposure case, or it could be a total case, right? That's when you should be thinking maybe a functional capacity evaluation would give me a better idea of this person's actual working ability and functional impairment, okay? Because that's what it can address. And so I would pose the question in my cover letter to my IME doctor in those high exposure cases. I would say, do you think this IME should be done? And let's say the doctor writes their IME report and they don't address it, or they say no. I would then probably ask them to actually answer the question. I would ask for them to respond to a follow-up letter. And then certainly during the cross-examinations of all the doctors, I would be asking them, like their orthopedist and our orthopedist, I would be saying, hey, you know what a functional capacity evaluation is, yeah? They're objective, right? They're measured, yeah. They can determine someone's physical impairment if it's fixed and arrested, yeah. It can also tell if someone's putting effort in, yeah. You understand that they're relied on in your field as the gold standard for determining functional ability. Yes, yes, yes. You get them to agree to all that. And then I would make an argument in front of the judge by way of RFA that the judge should require them to attend a functional capacity evaluation, okay? In the cases that I've deployed this, where I've gotten a functional capacity evaluation, either the IME to recommend it, I've had opposing counsel really not do much to oppose it because it's not really done that often. But the other thing I would tell you is when you do get that functional capacity evaluation conducted, the good news is opposing counsel is not going to go and get their own, because there's no provision in the medical treatment guidelines or the fee schedule for it. And so there's no way they can force us to pay for their own to get a contradictory one. Also, my experience with functional capacity evaluations is it is quite objective and scientific. And so there isn't really like a plaintiff-friendly functional capacity evaluation vendor that anyone will be able to find that's credible. You might be able to find a chiropractor who will set up like a home gym and pretend that they're doing a functional capacity evaluation. You will not find a credible physiatrist or biomechanical engineer to do it. And so because we don't have to pay for them to go get their own, they generally won't be able to get contradictory medical. Also, opposing counsel is not versed in deposing physiatrists who are doing these evaluations or the biomechanical engineers. So you'll have an easier time getting that those proofs into the record, and then opposing counsel will have a more difficult time cross-examining them in a credible way. They just really won't be able to. So I think this is something to suggest in your high exposure case as a way of creating that contradictory and objective evidence that you can rely on and maybe get some progress on. And again, this is not right for your 25% LWEC back sprain, your single level discectomy, your single laminectomy, but that's not those cases. This is your cases that are looking like they're going for total, where you've got a 3-level fusion, and then they're claiming that they have a pre-existing learning disability and they should be considered total industrial, right? Like that's when this kind of stuff should be deployed. And also, I would say aggressive use of a record review as opposed to the luck of the draw on these IMDs, right? Like that's where we should be spending our time, blood, and treasure. All right. Last thing I'll just chat about is the horrifying onboard system that we are not allowed to have access to. If you have some time for some light reading, we all know the issues with onboard. There's nothing more frustrating, right, than filing an appeal on a case, and then they go and somebody approved a PAR and got them the treatment that you're fighting about, right? So believe me, I'm preaching to the choir here, but I'm also trying to educate clients about the coordination that's really necessary with onboard and making sure that we're not letting stuff slip through. The board is recognizing there's problems with onboard. Last month, if you go on the board's website, it's not a board bulletin, it's a board announcement. So it's not in the bulletin section, it's the announcement section saying, wow, we have all of these problems with onboardings. The repetitive resubmits is still going on like crazy. That's why you'll see like C-8.1Bs, like 25 of them in a row in your case, because, these claimants doctors have learned they just keep resubmitting for the same thing, and eventually someone will forget to respond, and then they get to cut these poor people up and make them worse, right? So that's still going on. But that's where that fact and figure came from the first slide. If you read that, the board is trying to address the fact that the amount of medical disputes have actually increased since they deployed the system. And last year they said the number of medical disputes went up 20% to 1 million disputes over authorized medical. So it's getting worse from the board's perspective. And just remember, this onboard system that was deployed in 2022 was intended to side channel all these medical disputes and reduce them. It's actually made it significantly worse. And now the board's going to probably be taking action over the course of this year and next year to address it. The other thing that I think we're going to see from the board that we all know about is we've already started to see these horrifying CMS 15 letter replacing the C-4.2s and stuff, right? I hate these CMS 1500s where it's this crazy looking computer gobbledygook, looks like a Scantron form or something, from those of you who remember that. And then the next page is just some kind of crazy medical record, and they're never in any sort of easy to read format. And if you're a doctor like Sebastian Latuga, you always scan it with this like crappy garbage scanner, so I can barely even make out what it's saying. So those are the CMS 1500 forms that have plagued our system, and it's usually looks like a crazy computer gobbledygook, and then behind it is like a medical narrative you can barely read in no discernible format. The board is trying to address this. The board has issued what they want people to use as a template narrative. So your medical narratives, they want to push everybody into a format, but they can't require it. The only thing that they are requiring is by August of 2025, so this August, all medical forms will have to be on the 1500, the CMS 1500. But again, they are not standardizing what the medical report format is. So you're going to continue to see the kind of crazy reports that you're seeing now, where you've got to go through a lot of gobbledygook, and usually it looks to me like a lot of copy pasta before you can figure out what this report's about. A lot of copy and paste. All right, so takeaways for us today. I know this stuff is all tactical, and these feel like small moves that we're making in our cases. I know we want to have fun with the big moves, but this is stuff that you can try, and if you can get some leverage in your case, you can amplify that perhaps into a strategic closure. I also think that reducing new body parts, like that's a win. We don't post those on the website, but that's a win. So fight those where they come in. Let's try to use common sense on some of these things. Like, Judge, it's been a year of physical therapy. They're not getting any better. Why more physical therapy? Like say those words out loud. I know it's not going to have any impact whatsoever, but I think some canary in the coal mine needs to be there. And the last thing I'll say is, like, we have to get creative with medical. This is not the slam dunk that labor market attachment is, or fraud. I get it, right? So it doesn't get as much emotional energy behind it. But if you look for things like undue influence, you start to think about, hey, how could I maybe get a better IME report with a better letter? Or could I try a functional capacity evaluation in my worst cases and just see if you can get some traction with those things? I'll stand behind you in trying those kinds of tactics. All right, that's the conclusion of our presentation. Thank you, everybody.